Today, we have a 7-bedroom and 3-bathroom house here in Mission Heights. With open plan living and a newly renovated space, this house is perfect for a medium to large size family. And guess what? Today I'm going to show you what you need to be able to do to sell it. When taking on this listing, you want to make sure the outcome of it is you getting that hard-earned commission and that the family moving in here has no conflict and is able to move in here comfortably.
First things first, you want to make sure you have a written agency agreement signed by or behalf of the client and the agent. This will confirm that you are able to carry out any agency work and ensure that you get your paid commission, as Section 126 of the Real Estate Agency Act state that there is no entitlement to commission or expenses without an agency agreement. The agency agreement will have to meet regulations of Section 156 of the Real Estate Agency Act, one of them being entitled to be licensed as an agent, branch manager, or salesman. Along with this, you will need to give a statement providing the estimated sale price for your property, the methods you recommend to sell the property, the commission fee along with how it's calculated, the expense the vendor will pay for, and when your agency contract ends.
As an agent, you have a fiducial relationship between you and the vendor. It is important to disclose this because the law may assume there is a potential bias if you know the vendor personally. You as an agent have the authority to receive communication, however you cannot commit the vendor to the contract. Once the contract is signed, you as the agent can take the property to the market.
Taking the properties to market, as an agent you have a duty of care, therefore a reasonable analysis of the property must be made, and an information pack must be made with the vendor's lawyers, which will then be passed on to the potential purchasers. This should include all known traits about the property, including defects. If the property wishes the agent to withhold any information from potential purchasers, the agent is allowed to cancel the agency agreement. If they do withhold this information, they'll be violating Section 73 of the Real Estate Agency Act. If they do tell this information to the purchasers, it will be disobeying the vendor's instructions and therefore violating the agency contract. This will prevent misrepresentation and ensure information is provided to make purchasers comfortable and aware of the potential purchase. If misrepresentation or inaccurate information was to be made, this will be breaching Section 64 in the Contract and Commercial Law Act 2017. Looking at the Smythe v. Bailey's case, Bailey's were found to be misrepresenting their listed property to their buyer Smythe. Bailey's had over-exaggerated the current rental income generated from the property to be $80,000 per annum. However, the rental income was only $40,000 due to an agreement prior to Smythe purchasing the property. Smythe ended up claiming $480,000 in damages. It is also good practice to record any person who attends open homes to secure agent commission in the case that any of them were going to make an offer. If a vendor wishes to act on an offer you have communicated to them, a written sales and purchase agreement document will be needed to prepare in order to be compliant with Section 24 of the Property Law Act. The most common format in New Zealand is the ADLS template. However, if you wish to make a custom clause such as a due diligence clause, it needs to be compliant with clause 10.8 and a fixed time needs to be determined for these conditions to be fulfilled by. As the agent, you should also recommend that the purchaser seeks out legal advice about the contract, ideally from multiple people, to get their opinion on entering this contract. Referring to Mr. Benjamin v. Pascoe Properties case, Mr. Benjamin was an agent appointed by the government. Benjamin negotiated a purchase price of a property with Pascoe, and once they did agree on the price, both parties signed the contract. This gave the impression to Pascoe that Benjamin could legally bind the contract to the transaction, but in private emails the government said that Benjamin could only negotiate prices, not legally bind the government. Although Benjamin was not given actual authority to legally bind the government, it was ruled that Benjamin had the ostensible authority to do so, as Benjamin had signed contracts on behalf of the government before in similar transactions previously that were approved by the government. If Benjamin would not have ostensible authority, if they had been corrected on this issue, but since the government approved of these contracts, it gave the impression that Benjamin had the ability to bind the contract this time. The deposit payment is usually about 10% of the purchase price and should be paid immediately on execution date or at the latest the day after. If it's late, the vendor can charge penalty under clause 2.3, and if it's really late, the vendor can cancel the contract within 3 days working notice. Deposit has to be bank transferred or bank checked, as it needs to be cleared the same day. It needs to be paid to the vendor or the vendor's agent. The vendor or the agent will hold the money as a stakeholder, and the vendor becomes an independent third party. Clause 2.4 states that the period of stakeholding till requisition period is completed until each condition is being fulfilled. Once the contract goes unconditional, then the money goes to the vendors. No one can use the money during the stakeholder period unless the contract is amended, and if it's a unit title, then disclosure obligations have to be completed. The deposit may be forfeited, for example, where the building could have problems and if the conditions aren't satisfied, so the purchaser could get a refund. However, if the purchaser pulls out, the vendor gets to keep the deposit money. Settlement. Now moving on to the settlement, and this is where it gets exciting. The purchaser's lawyers will transfer the remaining money to the vendor's lawyers. The purchase lawyers will also handle the transfer of ownership and record of any mortgage on the title. When the documentation and payment has been received, the keys will be handed over to the purchaser's lawyers for them to collect. As a real estate agent, your job in this process is to simply comfort and congratulate the new owners with the property.